go? My computer freeze? You got to be kidding me. There we go. Okay. All right. Once again, the book is considering this kind of one of the opening conflicts of the Civil War. What we have here are the basic facts with Dred Scott. Dred Scott was a slave from Missouri. His owner was in the military, and he was ordered from Missouri to go up into the north, up into Illinois. He lives in Illinois for a couple of years. Then he's transferred to Wisconsin, which is a free territory. Okay, so Dred Scott is living in the north with his master for several years. He's allowed to get married to a free black in the north. Okay, they have a child. The child is born on free soil. But at the end of the time of his master's stay in the north, he returns to Missouri. At that point, his master dies, and he is sold as property of the master's estate to a woman. Okay, now the woman and her husband have a little bit of a disagreement over the slavery issue. He's actually in support of Dred Scott's ability to be free, and he helps support Dred Scott in bringing a lawsuit to Missouri State Court. And the lower courts in Missouri actually find that because Dred Scott had lived on free soil, that he was a free person, okay, and no longer property. But the case, because the woman who owned Dred Scott moves to New York, a free state, but still wants to keep Dred Scott as her property, she sues or she appeals the lower court decisions up into federal court. So national level court, okay? The lower court rules in favor of Dred Scott's owner. So Dred Scott appeals his case to the highest court in the land, the very final decision makers, the U.S. Supreme Court, okay? They take this simple issue over whether Dred Scott is a person or property, whether Dred Scott was a free person or a slave because he lived in free soil, and they create a legal precedent that's going to overrule the Missouri Compromise, the Compromise of 1850, the Kansas-Nebraska Act, all of the compromises we've been talking about that Congress made. The Supreme Court's decision is going to blow those out of the water and blow the lid off of nationalized slavery. Okay, and here's how. First of all, they look at Scott's citizenship. Okay, today, a person, if the court was considering whether or not you have the ability to bring a lawsuit to a federal court, they would look at the 14th Amendment. The 14th Amendment protects everyone to equal protection under the laws, regardless of their citizenship status. So anybody under the jurisdiction of the laws has equal protection. That's the 14th Amendment. But we don't have the 14th Amendment in 1857. The precedent, the standard for citizenship in 1857 is that every state decides for itself what is citizenship. Okay, can you imagine that today as we deal with illegal immigration? A lot of Southerners, I think, or conservatives would be happy to allow states to decide citizenship laws and whether or not, and to enforce citizenship laws. But citizenship today, we look at it as a federal or a national decision. In 1857, the 10th Amendment is interpreted as saying it's up to the states to decide. So you look at Missouri. Are black people citizens in Missouri? No, they're property. Okay, so the Supreme Court, the Chief Justice of the Supreme Court is a guy by the name of Roger Taney. Rules number one, Dred Scott doesn't even have the right to bring a case here. Slaves are property, not people. Number two, okay, that the local laws, state laws, are to be respected. Okay. Article 4, Section 1 of the Constitution says that states need to respect one another's laws. So he takes that particular passage and he applies it basically to Illinois, saying, look, under Missouri law, Illinois can't disregard Dred Scott's status as a slave. But let's get to the more important part of this. Not only does he declare that Dred Scott is property and not a person, but he goes further and says that the Fourth Amendment of the Constitution, now you guys should know about the Fourth Amendment because if you're ever pulled over by the police, right, you are protected from unreasonable search and seizure without probable cause or a warrant, right? You, as citizens, have the right to life, liberty, and property. Those are all constitutional protections. Roger Taney, Chief Justice of the Supreme Court, rules that Dred Scott's owner has had her rights violated by her property being able to walk off and not be captured and brought back to her. So, in essence, all slave owners have a right to property, which protects them no matter where they go in the whole country, because the Constitution is a national set of rules, that slave owners have a right to property wherever they go, which means a slave owner can take their property up into the north and practice the institution of slavery. So it eliminates all of this compromise over where can slavery exist. And basically the question is answered with anywhere. Okay. Any questions about that? Yeah.
Someone told me that if a cop does ask to search your car and you say no, that they'll just call their favorite judge and get a warrant in 5 minutes anyway.
You know, you're dealing with the difference between the ideals of our Constitution, okay, what is technically true versus what is practically true. It's technically true that you need to have reasonable cause, right? Probable cause to get a warrant. And in order to get that warrant, the officer would have to be able to articulate that a crime has been committed and there's articulable evidence to show that that person is the one that committed the crime or the one that possesses whatever it is that's being searched or seized, right? Probable cause. Now, what your friend or what this person is saying is that law enforcement has a good relationship with the courts and they won't have a difficult time in getting a search warrant. That's a reasonable thing to say, although I think most judges take their job seriously and do a good job in making sure the standard of the law is upheld. I think that most police officers can articulate it in a way that would give probable cause. So I guess it would depend on the example, but are you thinking about like searching your car?
Yeah, we were just talking and he said something.
Mm-hmm.
He said that.
I think it really depends on how dedicated the cop is.
Yeah.
Like if they obviously see like marijuana right there, then they're gonna be like, let me search your car. But
Well,
you're already there.
probable cause could be you match the general description of the suspect. Your vehicle matches the general description of the suspect's vehicle, and you're in a high traffic. You're in a place that's considered a high trafficking area, right? And so you tell me where in Omaha you can be that couldn't be considered high drug trafficking area. At that point, well, we've got a white male in his late teens, early 20s, driving a four-door black sedan. I mean, I'm basically describing everyone in this room that's a male and he was in a high drug trafficking area around Bennington High School. I mean, at that point, okay, well, and how can we pin that down to Jacob Raby? Well, you know, at that point, the judge might say, okay, well, how certain are you about this? And officer, 98%, right? And so there's probable cause there. If you're matching the description, you're in an area where it's probable that this activity was going on. Now, as far as like traffic stuff, traffic violations, that type of thing, what should you do? You have two choices. You can cooperate, or you can be real hard-nosed about what your rights are. I guess the approach that you take, what I'd recommend is always be respectful, and your time to argue your case is not out on the street at 9 o'clock at night with a police officer. If you're going to maintain your rights and you're going to try to follow the letter of the law and protect and be a constitutional crusader, expect the cop isn't going to cut you any favors. They're going to follow the letter of the law too. You just need to do your best to remember and document how you tried to maintain your rights, but then you'll argue that in front of a judge because you're probably going to go to jail. You're probably going to get a ticket. Because, so what's the value of cooperating? Sometimes the cop will use their discretion. And for example, how many times have I been told, well, you were going 70, but I'm going to write this for 65. Right?
Mm-hmm.
Great, thanks. But you got to decide for yourself, but expect though the time to argue about your rights will be in court. Yeah. Dred Scott couldn't argue about his rights. He had no rights.
Oh, that's sad.
So this is what we need to remember. The Dred Scott ruling basically declares all these congressional compromises as unconstitutional. It opens up slavery to the nation. Southerners take this as a big victory. Indeed, it was. It's not good for these compromisers like Stephen Douglas, who supported popular sovereignty. They believe the court is trampling on the sacred rights of the people to decide for themselves how their government should run. Okay? Which is where we, in a little bit here, when we talk about the Lincoln-Douglas debates, one of the things Lincoln does to try to get under Douglas's skin and to get him to criticize the courts is he asks basically, what's more important, the court decision or popular sovereignty? Okay, so we'll deal with that, but they're not happy, and it's a further wedge between the North and the South. Northerners are ticked. Obviously, this basically opens up all territory to slavery. They're going to say that this constitutional decision, that the Supreme Court doesn't need to be listened to. We would call that nullification, right? What region of the country was famous for nullification? The South. But now here we have Northerners talking about nullification or ignoring the law of the land. So it isn't a matter of bad guys, oppose the government, good guys support it. Both sides, when they're unhappy, start to get real critical of the Constitution or critical of one part of the government or another. Okay. Tomorrow we'll talk about the election of Abraham Lincoln.